Welcome back. We are continuing with our criminal courts and we are moving on to courts dealing with cases under disciplinary law. These are the courts which are provided for on Section 193B of the Constitution. I shall read Section 193 subsection B. Only the following courts may exercise or be given jurisdiction in criminal cases: a court or tribunal that deals with cases under a disciplinary law to the extent that the jurisdiction is necessary for the enforcement of discipline in the disciplined force concerned. These courts which may exercise criminal jurisdiction for disciplinary purposes in terms of Section 193B of the Constitution include the court-martial, the prison board of officers, the police courts, the children's courts, and the parliament sitting as a court of a breach of parliamentary privileges. The courts-martial are established in terms of Section 45 of the Defence Act. Section 45 of the Defence Act reads, "Subject to this Act, a court-martial may, inside or outside Zimbabwe, try any member for an offence in terms of this Act. Any person within the period of 3 months after he ceases to be a member of the regular force for an offence in terms of this Act committed while he was a member, or for an offence in terms of paragraph 2, subparagraph 1 of paragraph 15 or paragraph 30 of the first schedule, committed while he was a member, and may impose the punishment prescribed by this Act." The jurisdiction of the court-martial is to try members of the defense forces for crimes committed in terms of the Act. Some of the crimes specified by the Act are common law crimes. Ordinary criminal courts have concurrent jurisdiction with the court-martial, and this jurisdiction overrides that of the court-martial. This means that where the court-martial have tried a member of the defense forces, an ordinary court can also try that member, provided that they take into account for the purposes of the sentence the punishment that have been already imposed by the court-martial. The Police Act allows for a board of officers to try members of the police force who have committed offences under the Defence Act. This is in terms of Section 29A subsection 1 of the Police Act. Section 29A subsection 1 of the Act reads, "Subject to this part, a member who commits an offence in terms of Section 29 may be tried by the High Court or a magistrate court or a board of officers, or an officer in terms of Section 34. This means that offences may either be tried by the police board of officers or an ordinary court, and a police member is entitled to elect or to choose whether to be tried by the board of officers or to be tried by the magistrate court or an ordinary court in terms of Section 32 of the Act. Section 32 of the Act reads, "If notice is given in the manner and time prescribed by a member whom it is proposed to try before a board of officers in terms of paragraph C of subsection 1 of section 29, that he wishes that the charge against him be tried by a magistrate court and not by a board of officers, the charge shall be tried by a magistrate's court." A person convicted of an offence by the Board of Officers may also appeal to the High Court against the sentence or the conviction or an order of the Board of Officers in terms of Section 33 of the Police Act. An officer in the prison service may be tried for an offence by a board of officers appointed by the Commissioner of Prisons in terms of Section 52 of the Prisons and Correctional Services Act. Section 52 subsection 1 of the Prisons and Correctional Service Act reads, "The Commissioner General may, either generally or specially, appoint a board and a prosecutor to hear and determine any alleged offence against discipline by a correctional officer. A board appointed in terms of subsection 1 shall consist of 1 or 3 correctional officers who are either commissioned correctional officers or are officers in charge, and where such a board comprises of more than 1 correctional officer, the most senior correctional officer shall serve as chairperson. Where the accused correctional officer is a commissioned correctional officer or an officer in charge, the board shall be specially appointed, having due regard to the circumstances of the offence, and shall, as far as is practicable, consist of at least 2 commissioned correctional officers of the same or higher rank as the accused correctional officer. The prosecutor referred to in subsection 1 shall be appointed for his or a relevant knowledge and expertise and shall prosecute any officer regardless of his or her rank. Any correctional officer who is a material witness or who has personal interest in a case brought against any other correctional officer shall not be eligible to be appointed as a member of the board determining such a case. The chairperson of a board shall record or cause to be recorded in writing all evidence which is given before the board. The board cannot impose a sentence of imprisonment, but it may order dismissal of the officer in terms of Section 66 of the Act. Section 66 of the Prisons and Correctional Service Act reads, where the board has convicted the correctional officer, it may sentence him or her to reprimand, severe reprimand, extra working days for a period not exceeding 7 days, stoppage of pay where there has been absence without leave or loss by negligence of or injury to public or inmates' property, compensation for the loss or destruction or replacement of public monies or property, fine not exceeding 1 month's pay, withholding of promotion for a period of 1 year, reduction in a rank, requiring the correctional officer to resign or retire from the service with effect from a specified date, failing which the correctional officer shall be deemed dismissed as from that date, warning of dismissal. Prisoners may also be tried for prison offences by the Commissioner, but this is only in respect of minor offences and no sentence of imprisonment may be imposed. In all other respects, prisoners who commit prison crimes may be tried by a visiting magistrate or an ordinary magistrate court. Children's courts are established in terms of Section 3 of the Children's Act. Section 3 of the Children's Act reads, the minister responsible for justice may, after consultation with the minister, establish a children's court for any area of Zimbabwe. Every magistrate court shall be a children's court for any part of the area of its jurisdiction for which no children's court has been established in terms of subsection 1. The Children's Court does not try children for criminal offences, but may deal with a child who has been convicted by another court. Where no specific children's court has been established by the Minister of Justice, a magistrate court shall serve as a children's court for its area of jurisdiction. In dealing with a convicted child, the Children's Court has several options as provided for in Section 20 of the Children's Act. These options include ordering him to be placed in a training institute or be placed in the custody of any suitable person or to attend a specified center at specified days and for specified hours. So the normal procedure is that when a magistrate court or high court convicts a child, it decides whether or not to refer the matter to the Children's Court. If the High Court or the Magistrate Court decides to refer the matter, then the Children's Court takes over the matter as we have just explained. Parliament enjoys what are called privileges for the purposes of enabling it to carry out its constitutional duties. In Zimbabwe, these privileges are regulated by the Privileges, Immunities and Powers of Parliament Act, which was passed in accordance with Section 148 of the Constitution. Section 148 subsection 2 of the Constitution provides, an Act of Parliament may provide for other privileges, immunities and powers of Parliament and its members and officers. Therefore, in terms of Section 148 of the Constitution, Parliament enjoys privileges such as the freedom of speech and debate, exemption from attendance at court while in attendance at Parliament, and the right to punish for contempt or breach of parliamentary privileges. In exercising its right to punish for breach of parliamentary privileges or to punish for contempt, the Parliament is entitled to sit as a court. Section 16, subsection 4 of the Act provides as follows. Parliament sitting as a court shall have all such rights and privileges of a court of record as may be necessary for the purpose of summarily inquiring into and punishing the commission of any act, matter, or thing in which this part is declared to be an offence. This right extends to both over the members of the Parliament and the members of the public who are found to be guilty of contempt of Parliament. The procedure normally followed is that once any member raises a complaint of breach of privilege, the Speaker of Parliament must make a ruling whether or not there is a prima facie case. If there is a prima facie case, a privileges committee is appointed to investigate the complaint. The composition of this committee is in proportion to the representation of political parties in Parliament. Normal practice requires that the person against whom the complaint is made be given a hearing, including legal representation before the committee. The committee will report its findings and recommendations to the whole House, which must in turn resolve whether to accept or reject them. A member found guilty may be suspended, expelled from the House, or even be imprisoned in terms of Section 32 of the Act. Section 32 of the Act reads, "It is declared for the avoidance of doubt that any person adjudged by Parliament to be guilty of a contempt which is not an act, matter, or thing declared in Part 5 to be an offence may, in addition to any other penalty to which he or she is liable by virtue of this Act or any other law, be committed to prison for such period during the current session of Parliament, as Parliament may determine, which period, however, shall terminate on the adjournment of the next sitting of the House, which adjourned first after the sitting during which person is committed to prison, or on the prorogation or dissolution of Parliament, whichever is the earlier date. Therefore, if a sentence of imprisonment is given, it terminates at the end of the session of Parliament in which it was imposed. This marks the end of our discussion on criminal courts. Our criminal courts, we have the main criminal courts, which are in terms of Section 192A of the Constitution, the High Court, the Constitutional Court, the Supreme Court, and the Magistrates Courts being the lowest. And then we have other tribunals which act for disciplinary purposes in terms of subsection B, such as Children's Courts, Police Board of Officers, the Courts Martial, and so on. Don't forget to like and subscribe, and please do click on the notification button so you never miss on our latest updates. Your subscription and likes helps YouTube recommend us to a broader audience, and so we also manage to continue doing the work we are doing here on Legally Dephine. If you are new here, make sure to visit our channel on Legally Dephine for more legal content. See you on the next video.